and I've seen your homeworks as well. So you have done quite well. And I preferred some of the students' homeworks. They were too good. And I've given my comments as well. But for this subject, just a gentle reminder, always, always, for all the answers, you are expected to, add case laws. Okay. And there's for the previous question that I had asked, three important case laws were, of course, Balfour versus Balfour, Carlyle Carbolic Company's case, Carlyle versus Carbolic Company, and the third one was the Harvey versus Fassé. So these are some of the landmark decisions that have to be there in your answer books for your exam. Now, apart from that, you can add additional case laws as well. That is just to accentuate your answer and just to give just to put your best feet forward. That's the only thing. But yeah, your homework. I mean, I went through it all and it was too good, and I really liked it. So in this way, I guess you're getting ready for your exams as well, because the first question for the homework that I gave, I mean the entire stuff is an important question examine for your examination point of view. So now let's move on to study the concept of acceptance. See, last class we spoke about the general requirements of a contract. We learned about what is a contract, and we said that I taught you an equation in the form of equation. There's simply saying that offer plus acceptance is contract. So if you put it in a sentence form, you just say that a contract, I mean, offer plus offer plus acceptance, not a contract. Offer plus acceptance would form an agreement, and an agreement which is enforceable in law is a contract. So last time I gave you this equation saying that contract plus acceptance is agreement. So that means offer, we studied what is offer last class. We went through it in detail, and that's how we came up with the case law of Balfour versus Balfour, Carlyle versus Carbolic Smoke Ball Company, and so on. And today we are going to learn the concept of acceptance. So picture this: offer plus acceptance is agreement. So we studied offer. Now we are going to study what is acceptance. Now, what is acceptance? In simple, English language, or just in normal parlance, what is acceptance? Acceptance is something where you would, you know, it's like approval. Acceptance typically contains the concept of approval, where a person says yes to something. So what is contractual acceptance? It's the same thing. It's the act of agreeing to form a legal binding agreement. So when we apply approval to contractual sense, or in contract parlance, it is an act of agreeing to form a legally binding agreement based on an offer provided by some party. So it is an essential element of a contract, and without it, a contract will not be valid or will not be binding. So again, I'm repeating: offer plus acceptance is agreement. An agreement that is enforceable in law is a contract. So today we are learning what is acceptance. And I said that valid acceptance is a must. Valid acceptance is a crucial element in an agreement, and that agreement, when it has an enforceability factor, it will make it as a valid contract. So therefore, it is a manifestation of an assent or consent to the terms of the offer that is made by whom? By the offeree. I said there are two parties. The one who offers is the offerer, and the one who accepts the offer is the offeree, or to whom it is made is the offeree. So acceptance is a manifestation of consent or assent to the terms of the offer, which is made by the offeree in the manner invited or required by the offer. Okay, so why is it important? Why is, or what is the importance of acceptance? Because a person or the offeree fully acknowledges the fact of the situation and does not fixate on how it shouldn't be that way. I mean, he accepts the and all the other factors that are revolving around the agreement terms, and he consents uh, to the negotiation, or he consents to the terms of the offer, and he said yes. He will say yes, we are willing to go with this particular offer. So he consents to. So that is acceptance. So therefore, the major requirement of a valid and enforceable contract is that there must be an agreement, and that agreement must have two parties, the offerer and the offeree, and there must be a valid acceptance of that offer. So now, having set the perspective, let's move on and study what is acceptance from the slides, and also we'll see certain case laws, and we'll also go through certain examples. So acceptance is to signify assent or express one's consent, or to do or not to do something. That is in simple terms. But as per the Indian contract law, this I've just given you an example of a definition of Indian contract law, because I mean it's very easily defined there. When the person to whom an offer is made signifies his assent thereto, the offer is said to be accepted. So you can come up with even some other definitions of acceptance if you find from contract laws. Okay, so as per the Indian contract law, when a person to whom an offer is made signifies his assent, that means he signifies his consent. He says that okay, I'm willing to go ahead. So in one word, he signifies his assent. One word is assent. Thereto, the offer is said to be accepted. Thereby, only when an offer is accepted, an agreement and the possibility of it culminating in a valid contract kicks in. That means, what does it mean? When the other party accepts the offer, that is when there is a possibility that yes, now contract is being negotiated now. Now the next part of it is going to be the enforceability part of it. So they're going to enforce it, or they're going to check the various elements that would make the contract worthy of being enforced. Like I said earlier, it should not be by a minor, it should be by a person who's of normal mind. So all these are enforceability factors. The question is whether at all it can be enforceable in law. So that's why the definition of a contract is offer which is accepted is an agreement, and an agreement that is enforceable in law is a contract. So when the offer is accepted, it becomes a promise. So more clearly, when the offeree to whom offer is made signifies his consent or assent, which means when he accepts the offer, this act of acceptance operates as a promise to proceed with the agreement. Why? Because the offerer expresses his willingness to be bound by the term, so thus the offer is accepted now. So where he expresses his willingness to be bound by the term, so the offer. So thus, acceptance is an important element in an agreement and a contract. So what is the effect of acceptance? Just even without going through the slides, what is the effect of acceptance? What comes to your mind? It is just that now, once the offer is accepted, now they will move ahead with the agreement. Now, whatever are the terms of the agreement, they're agreeing. Okay, fine. So now it becomes a promise, and the elements of the offer and acceptance legally bind both the parties. So now he trusts the other person. So, for example, like I give you an offer and you accept it, and then you say, okay, fine. Okay, I say I'm going to sell a piece of land to you, and then you accept it. So now you know that okay, I'm not going to sell it to anybody else. So I'm going to sell it to you. So it binds me and you. I'm the promiser, you're the promisee. I'm the offerer, you're the offeree. So it binds both the parties, the offerer and the offeree, to the proposed transaction. Now, who can signify the assent? Now, for an acceptance to be termed legally valid, such acceptance must be expressed by a person to whom the offer is made and not the neighbor or anyone else. Now, this is obvious. I mean, this is a simple factor that would just again normally come to your mind. Like, for example, if you make an offer to me to sell my land, so my neighbor cannot accept the offer because he or she becomes a third party, right? Or if I make an offer to you and then for me to legally enforce it, I'll say, okay, um, anyone. So, okay, Kader. So if I make an offer to Kader to sell a plot of my land, and then he says, yes, I'm willing to buy it, and okay, so I agree to buy it. Now, let's go and draw up the terms of the contract. So he accepts it. So suppose he has a neighbor and he says, okay, Kader has said yes, he's willing to purchase your plot. I would say, okay, fine. So that just becomes a normal talk between me and him. But who is a person who can legally accept the offer is the one to whom the offer is made, and not the neighbor or anyone else. Next is essentials of valid acceptance. So this is an important fact. I mean, these are some of the important factors or significant factors that go on to prove whether at all the acceptance that has been made, whether it is valid or invalid in the eyes of law, whether it can be accepted in the eyes of law as a valid acceptance or not, whether it can be construed as a valid acceptance or not. So for the first thing is acceptance should be communicated. It has to be communicated. Okay. So for acceptance to be considered valid, it must be communicated. Later on, we'll study whether silence can be considered as acceptance or not. But for now, we will confine ourselves to understand whether it has to be communicated. So for acceptance to be communicated, valid or considered valid, for acceptance to be considered valid, it must be communicated by the offeree to the offerer. For the mental determination or accepting in mind without conveying or communicating to the offerer is not a valid acceptance. Like, for example, I offered Kader my piece of land for X amount of money, and Kader does not respond to me. Or say, Ali Muhammad, he wants to sell his plot of land to me, and he says, okay, this is my offer, and I don't even communicate. In my mind, I say yes, 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 but I don't even open my mouth, or don't send him an email, or so don't send him a text, or I don't communicate at all. So this is not a valid acceptance. Mental determination, accepting in mind without conveying or communicating it to the offerer, is not a valid acceptance. Next is acceptance should be absolute and unqualified. Acceptance should be made in a normal, usual manner unless the offer prescribes the manner of acceptance. Like, now what does this mean? Now, Ali Muhammad has said that he is going to sell his piece of land to me, and I need to accept the offer. He says, if you accept the offer by sending it to me in writing, then I would say that, yes, you have agreed to purchase my property. Okay. So if he says, oh, now he says, okay, you have to give it to me in writing. But then I just verbally tell him, yes, yes, I agree. So there is a manner of acceptance that is decided between the parties. So for acceptance should be normal, it has to be made normal, usual manner, unless the offer prescribes the manner of acceptance. So now there is a specific condition here saying that no, I have to communicate my acceptance in writing. It can be email, it can be text, or it can be letter, or it can be just a document that I type, or whatever. So it has to be in writing. Okay. Next is acceptance should be iPhone. Just let me know who you are. Okay. Then acceptance must be within a reasonable time. It has to be within a reasonable time. Now, Kader says he wants to sell his land to me, and then after that, I don't respond to him at all. I come back after 3 years and say, "Oh, what happened about the land? Now, okay, send it to me." They said, "No, I sold it to somebody else." Then I said, "No, you promised to sell me. Where is a promise when I have not accepted it in a normal way, and I've not communicated to him within a reasonable time. So of course it should make sense to you. I hope it makes sense. So acceptance must be within a reasonable time. So this makes sense. Acceptance should be made before the revocation of the offer. So acceptance, I should communicate my acceptance before Kadir says, well, I changed my mind, or the plot of land is sold for X amount and now it is X plus Y. Okay, so then I would say, okay, I think it's difficult for me. Then he said, okay, I revoke my offer. Okay, I take back my offer, or I'm not interested in selling it. Or Mr. A wants to sell his land to Mr. B, and Mr. A's wife tells Mr. A, come on, you're selling it for quite a less price. And Mr. A does not know how to tell Mr. B, well, I'm not interested to sell the plot of land to you. So how can Mr. A tell Mr. B, well, my wife told me, he'll not go into those personal details, but he'll say, no, I'm not interested to sell my plot of land anymore. So there is revocation of offer. So acceptance should be made before the revocation of offer, right? There's yet another element here. Suppose there is an acceptance of offer. Suppose there's an acceptance of offer, and the other party, that is the accepting party, the party to whom the offer, that is the offeree or the promisee, he acts upon that offer. He acts upon the offer. For example, now, what shall we say? Okay, now, say Mr. A owns a car and he decides to sell his car, and because there is one Mr. B, he desires to purchase Mr. B's car. Okay, there is one Mr. A and he desires to purchase Mr. B's car, and Mr. B has made an offer. It has been accepted by A. Okay, A says, well, okay, I'm ready to purchase your car, and they've already decided the terms, and they have just spoken to each other, and they already decided the terms. And now Mr. A relies on Mr. B, and what he says, well, I got an old car. What I'm going to do, I'm going to sell it as fast as possible just to make garage space in my yard. I just need to make some garage space in my yard. And so what he does is he sells his old car, and then he makes space there. And by the time he goes to B, and B says, well, no, I couldn't, uh, sell the car to you. I sold it to some other person. So, I mean, again, this is not an acceptable situation. Why? Because he has acted upon that promise. He has acted upon that promise because there was an arrangement there. He's accepted the offer, and that guy has promised, B has promised to sell the car to A, and A has acted upon the promise. And now to go to work, he does not have a car, and it's difficult for him to arrange another car immediately. I mean, it's just kind of a simple example I'm giving you so that it will be, it will go into your minds. So even such a situation is not acceptable. When a person acts upon the promise and puts the promisee, that is, puts Mr. A in a difficult situation, that means Mr. B is estopped, or he cannot take back his promise. So suppose there is a litigation and they go to the courts of law, then they would apply a principle called as promissory estoppel, and that is the topic on which you are writing your assignment. So that is promissory estoppel. So, well, now coming back to this, acceptance must be within reasonable time and should be made before the revocation of offer. It must be made in a normal, usual manner, unless the offerer or offerer prescribes certain manner of acceptance, or the offer prescribes the manner of acceptance. It should be absolute and unqualified, and acceptance must be communicated. So acceptance may be expressed or implied or even conditional. Acceptance may be communicated by an act, by words, verbally, or in writing. It may be implied. That means implied means it can be understood by the actions. It's implied. For example, when you board a cab or a taxi, it is understood that you need to pay the fare. When a condition is attached to acceptance, it is regarded as conditional acceptance. It is also referred to as qualified acceptance. So this involves a counter offer. For example, A agrees to sell B his horse, provided B agrees to sell him his stable at location X. So what happens here? There is a condition. So A agrees to sell B his horse, but provided B should, sell him his stable at a particular location, say location X. So this is called conditional acceptance or qualified acceptance when there is a condition attached to it. Or B agrees to sell goods to Q provided Q pays for the delivery charges. Or Ali Muhammad Ali agrees to sell his car to Muhammad Ali. I don't know. Are you the same person or okay, whatever? Ali Muhammad Ali agrees to sell his car to Kader Siad. Okay, and he says, okay, I'll sell my car to you, but there is one condition: you will have to come and collect the car. I will not drive it and send it to your place. Understand? So there is this is he said, and then he says, yes, I agree for that. So this is there is for this acceptance what he's agreeing. So there is a conditional acceptance there or qualified acceptance. So this involves, so P agrees to sell goods to Q. So he puts a condition, he accepts it. So or let us put it this way, so Ali Muhammad agrees to sell his car to Kader Siad, and Kader Siad says that yes, I agree to purchase the car provided you come and deliver the car to location A or location B. So then then this guy says, Ali Muhammad says, yes, I'm willing to come and deliver the car to you at location B. So this is again qualified acceptance. So P agrees to sell goods to Q provided Q pays for the delivery charges. Ali Muhammad agrees. Ali Muhammad agrees to sell the car to Kader Siad, provided Ali comes and delivers the car at a particular location that Kader is asking him to. So is silence acceptance? Generally, silence is not considered as acceptance. However, in certain circumstances, silence may be considered as acceptance. So let us see how and when. For example, suppose that A sends B some goods and A informs B that A expects payment. So if B consumes the product or uses it, then B has impliedly consented to the agreement. I'm repeating. A sends B some goods. A informs B that A expects payment. Now, if B consumes a product or uses it, then B has impliedly consented to the agreement. Now, if B uses the product, that means the meaning that is taken is yes. That means you have agreed it. Because how can you use the product? How can you use the product if you have not paid for it? So that means here they would draw a conclusion, or it can be construed as accepted or implied acceptance. So in some circumstances where the parties have been dealing with each other, this is yet another example. In some circumstances where the parties have been dealing with each other and are acquainted with the dealings, that means they're used to the dealings with each other, the silence may be interpreted as acceptance. So therefore, prior dealing may be an exception to the rule of silence as non-acceptance. So this circumstance normally happens in certain traditional commercial transactions. Certain traditional commercial transactions where, when they're acquainted with dealing with each other, when they're used to dealing with each other, even if the other party does not come back on time, there's no problem. He has not come back, but however, it is, he is going to come back anyway, and he's going to agree to the terms. So silence may be interpreted as acceptance. It depends on the facts and circumstances of each case, but this normally happens in traditional commercial transactions. Therefore, prior dealing may be an exception to the rule of silence as a non-acceptance. So waiver of express acceptance can be an exception as well, and silence may be considered as acceptance. Now, what's the postal rule on acceptance? Now, there is an important case law here, Adam versus Lindsay. The offeree's acceptance is good the moment the acceptance is posted. So it becomes effective the moment it is dispatched. In Adam versus Lindsay's case, so these are the facts of the case now that we're going to read here on the screen. Here, The defendant sent a letter to the plaintiff. Now, who is a plaintiff? The one who files the case in a civil law. I mean, under the civil law, or in a civil case. So a plaintiff is a person who files a case, and defendant is a person against whom it is filed. So the defendant sent a letter to the plaintiff offering wool for sale and asking for a reply in course of post. The letter then was misdirected by the defendant and arrived later than it would have been. The plaintiff replied at once, accepting, but the defendant, having decided that because of the delay, the plaintiff were not going to accept, had already sold the wool elsewhere. So what has happened? The letter was misdirected by the defendant and it arrived late. So the plaintiff replied, at once accepting, but the defendant has decided that because of the delay, the plaintiff was not going to accept and has already sold the wool elsewhere. So this is Adam was a Linsell case, and it's an old case of 1818. But this is a landmark case. The plaintiff then sued for the breach of contract. The court held, now this is what the court decided, that to require a posted acceptance to arrive at its destination before it could be effective would be impractical or not practical and inefficient. It would be much better if as soon as a letter of acceptance is posted, the acceptor could proceed on the basis that a contract has been made and then take action accordingly. I mean, those days, you had postal system. So what the courts said that it's not necessary that it reaches the person. The moment the letter is posted, it could be taken as acceptance. The plaintiff therefore succeeded. The defendant was in breach of contract. The offerer to have a change in mind or a withdrawal of the offer or made an offer with someone else is possible. But nevertheless, the court looked into the business, the business would be better served by giving the offeree certainty. That's the postal rule was created. So there was a rule called the postal rule. Like, how are they going to determine acceptance when the acceptance, especially in those days, was communicated via postal delivery or postal service? See, those days, when you post a letter, it takes time to reach the other destination, depending on where the destination is. Of course, you know that, whether it can take 3 days, 4 days, 5 days. So the rule here is it's not necessary that the letter reaches the hands of the person, but the moment the letter is posted, it could be taken as acceptance. Thereby, acceptance is effective on posting. Even if the letter is lost or delayed, the offerer is still bound. So this is the postal rule. Now, in the formation of contract, therefore, we need to understand what makes a contract, which is already defined, of course, in the previous section. Now, for a contract to be valid, there must be a valid offer, which we learned during the last class, the essentials of a valid offer. Today, we spoke about valid acceptance. So offer with acceptance is an agreement. Legal